Hi, I'm Nancy Cavey, National Social Security Disability Attorney, and it's my pleasure to speak with you today about what every CMT needs to know about Social Security disability benefits. There are two types of Social Security disability benefits. The first is Social Security disability benefits, and it's based on your payment of FICA taxes. And normally, depending on your age, you'll need to have paid in 20 out of 40 quarters prior to filing an application. The alternative is SSI, and I'll talk about that in a second. But SSDI pays benefits from the 6th month of disability or at least 12 months before the application, whichever is later in time. Now, the amount of your Social Security disability benefits is going to depend on your earnings record, how much you contributed to the Social Security system. You'll be eligible for Medicare after 29 months of disability. The first 5 months is a waiting period, so you won't get any benefits, but then you have to be receiving 24 months of Social Security disability benefits before you become eligible for your Medicare. Now, the alternative, if you're not insured, is what's called Supplemental Security Benefits, SSI. You can only have $2,000 in assets if you're single or $3,000 if you are married. Your car and your house aren't included. If you get your SSI benefits, your monthly payment is capped at $841 per month. But the good news is that you get instant Medicaid. Now, the Social Security disability claims process is generally a 3-step administrative process. There's an initial application, and normally pre-COVID, it would take about 60 days. Now it's taking longer because the Social Security folks are working from home or working remotely. They are going to be reopening the offices soon, but I don't anticipate that this process is going to be speeded up. Now, in the Tampa area, it takes a different amount of time than it does in Miami or in Chicago or wherever. There are different time lengths based on the number of claims that are being filed, depending on where you live. So I'm just trying to give you an average here. Now, the initial application, which is a pain, is reviewed by the Office of Disability Adjudications, called ODAR. ODAR's view of these cases is that they're looking for a reason to deny a claim, and as many as 90% of these can be denied. I don't want you to be discouraged. We never, ever give up. I do want to tell you that there are some common reasons why the claims get denied, and that is no doctor's records, no doctor supports, failure to accurately describe your work duties. So there are mistakes that you can make in the initial application process that will make it more likely that your claim will be denied. If your claim gets denied, and depending on where you live, you have to file what's called a request for reconsideration. You've got to do that in 60 days, and if you don't, you have to start all over again. Again, pre-COVID, it would take about 60 to 90 days to get a decision. It's reviewed by the same folks that denied you the first time. And quite frankly, you still get that 90% denial rate. Now, the common mistakes that are made at the request for reconsideration stage is the failure to tell Social Security about what's going on medically. New diagnostic studies or doctors that are now treating you, or changes in functionality. If you get denied 2 times, don't give up, because you have to file what's called a request for hearing to get you in front of an administrative law judge. That administrative law judge isn't bound by those earlier denials. It's a fresh set of eyes. But the judge is going to use the same 5-step sequential evaluation that's used at every stage of a claim, which I'm going to talk about in a minute. Now, it can take 16 to 24 months to get a hearing from the time of the initial application to the time you get in front of a judge. And again, this is an average, and it depends on where you live in the United States. Unfortunately, approval rates vary by ALJ, and you can actually look up the approval rate based on the judge that's assigned to your file. Now, if it's a low approval rate, don't get discouraged. That's just another reason why I think that you need an attorney. Right now, we are doing the Social Security hearings by phone. There is a move in June to go back to live hearings. I don't know how well that's going to work, but there will be an option for in-person hearings, phone hearings, video hearings. We're just going to have to work all this out as we deal with the COVID fallout. Now, Because I'm an attorney, I have to tell you that I think that Abe Lincoln gave us all some wise advice, and that is a person who represents himself has a fool for a client. And I think that's particularly true in these cases. But the obvious question is, how do I get paid? Or how does a representative get paid? We're paid a fee from your back due benefits. That's either 25% of the back benefits or a maximum of $6,000, whichever is lower. It's a one-time fee, and it's set by the Social Security Administration. Now, the attorney does have the ability to petition for a higher fee. That's not something that I do. Let's talk about the nuts and bolts of a Social Security claim. What is it that you have to prove? Well, I want you to understand that you have to prove that you're disabled. Just because you can't find a job or keep a job doesn't mean that you're disabled in the terms of the Social Security world. It's the inability to engage in any substantial gainful activity by reason of a medically determinable physical or mental impairment that can be expected to result in your death, or which has lasted or could last for a continuous period of not less than 12 months. That's a lot of words, isn't it? So let's try to make sense of these words. The Social Security Administration uses a 5-step sequential evaluation. So the first question they ask is, are you working? 2, is your CMT severe? 3, does your CMT meet a listing? 4, can you do the lightest physically demanding and intellectually simplest job you held in the last 15 years before you became disabled? And at 5, which is where most of these cases are decided, the question is, can you do any other type of work? So let's break this down in greater detail. Are you working? Now, the question is, are you unable to perform substantial gainful activity on a full-time basis? You can work, but if you earn more than $1,350, it's presumed that you are engaged in SGA and you're disqualified for benefits. There, of course, is an exception potentially if you're in sheltered employment. At step 2, we have to show that your CMT is severe. And this step is designed to weed out cases where there are only minor limitations on your ability to work, or your condition is expected to improve in the next 12 months. Now, in my view, that can be a hurdle depending on where you're at in the disease process. There are some cases that just aren't appropriate to file right now, but as the disease progresses, then the case becomes more of a winnable case. So it really depends on where you're at in your CMT disease process. Now, step 3 is a bit convoluted. When we studied biology, we studied the body in terms of body systems, and the Social Security Administration takes a body systems approach to the analysis at step 3. Now, there is what's called a listing under section 11.14 of the big book, the listing of impairments. And I'm going to take a moment to go over this because I want you to understand that if we're able to show that you meet a listing at step 3, you're automatically entitled to your benefits. We have to show a disorganization of motor function in 2 extremities, resulting in extreme limitations in the ability to stand up from a seated position, balance while standing or walking, or use your upper extremities. Now, we also have to have one of the following: difficulty understanding, remembering, or applying information, interacting with others, concentration, persistence or maintaining pace, or adapting or managing one's self. Now, you have to meet every one of those elements to get your benefits automatically awarded at step 3. If you don't meet a listing, and many people don't, then the Social Security Administration is going to determine how your CMT symptoms and limitations impact your ability to perform work. Now, doctors didn't go to medical school to learn how to write a report for Social Security that ticks off every element of these listings. So we're probably going to be at 4 and 5. At 4, the question is, can you go back to the lightest job you held in the 15 years before you became disabled? And in my view, the key to winning at steps 4 and 5 is what's called a CMT residual functional capacity form, and potentially a mental residual functional capacity form. Now, I want you to understand that Social Security Administration doctors who get involved in these cases, either looking at your records or doing a consultative exam, are going to opine that you're capable of light work, and that's going to result in an unfavorable decision. That's why I think that residual functional capacity forms are appropriate. Now, we use a peripheral neuropathy RFC form, and we modify it for our CMT cases so that it's more specific and related to CMT. But you need to understand that what the Social Security Administration is doing is they're looking at what's your residual functional capacity. How long can you sit, stand, walk, stoop, bend, and looking at the requirements of the lightest job you've had and say, do I think that this person can do their light work, their past work? Case is going to be won and lost at step 5 because this is a mythical, hypothetical, not real world test. Not a question of whether you can find a job or keep a job. The question is there other work that you could do in the national economy, mythical, hypothetical, not real world, taking into consideration your age, your education, your work experience, and your physical and mental capabilities. Now, there are 2 ways to get at this at step 5. I don't want to overwhelm you, but there's something called a grid. It's based on your age, based on your functional capacity. And we can look down and look across this grid to see whether or not you're eligible. And if you're 50 or older, that's where the grids are going to really help you. So if you're under 50, basically we have to establish that you can't even do sedentary work, using your upper extremities and maintaining the pace concentrations. Sedentary work, lifting 10 pounds, sitting 6 hours, occasionally walking, standing 2 hours out of an 8-hour day. I know that if I look at your medical records, I won't find that information, which is why it's important to have those residual functional capacity forms. Now, if you're over 60, it's going to be pretty easy to get your benefits, and you're probably going to get benefits awarded at step 4. But most likely, if you're, below 50, we're going to be looking at a sedentary type of earning capacity. Now, what happens if we end up in front of a judge is there's going to be a person who's never met you, and that's a vocational evaluator, an expert in the world of work. The judge is going to give them a hypothetical about your age, your education, the skills that you learned, and what they think your abilities are in terms of sitting, standing, walking, balance, coordination, that sort of thing. And that's another reason why you should have an attorney, because you need to be able to explain to the judge, the vocational evaluator, what your restrictions and limitations are and to modify that hypothetical. Now, as I've said, the key to winning is the ability to show you have problems with sitting, standing, walking, you have postural, manipulative restrictions, environmental restrictions, and that's the key, in my view, to winning the case. Also, if you have any problems with grasping, handling, fingering, understanding simple instructions, again, that's the key. So a lawyer or a representative's job is to develop the evidence and tell your story in a way that the Social Security Administration understands, and that's symptoms and functionality. But before you stop work and apply for your benefits, you need to know, is your doctor going to support your claim? Is the doctor going to fill out residual functional capacity forms? Now, this is a team. You have got to give your doctor a good history. I call it document deficiency disease, because many times when I read these records, there's no really good history of what your symptoms are and how your symptoms impact your ability to function, not only at work, but at home. So I want you to be careful about what's in your records. I don't want you to use what I call weasel words. You're feeling better. There's no new complaints. You're there to give the doctor an accurate and complete history of your symptoms and functionality. Now, as I said, that chart requires good teamwork, and the job of a lawyer such as myself or a claims representative is to help you tell your story. I thank you for listening to me, and I look forward to answering your questions. Now, remember, when I answer those questions, I can't give you a legal opinion that relates specifically to your case, but I'm more than happy to answer general questions. And if you would like a copy of this presentation, we'll make it available to you. Thanks.